This podcast, like all podcasts and pretty much anything I do on social media, is not legal advice and it does not create an attorney-client relationship. Instead, it's just for educational purposes, and gosh darn it, it's fun.
Welcome, everybody, to the Vana Room, and thank you again to our resident entertainment law expert, Mrs. Davey Jay, Esquire of Meehle Jay here in Orlando. You guys can check out the link below for their website and their socials. They're absolutely fantastic. They put out a lot of great little videos with little tidbits of info. So, Davey, thank you guys for doing that. And which I use for my class all the time, by the way. I hyperlink to your stuff all the time. Yeah. So thank you. So one of the things that we're going to be doing in the new year here is a contract series. So for all of you watching, please stick around, check it out. We are going to be talking about different types of agreements in the entertainment industry. And today is part one. And we're going to start talking about publishing deals. Now, my reference for this is from a book called The Introduction to the Music Industry and Entrepreneurial Approach. That link is also down below. And in this book, they talk about 6 different types of publishing deals. So we're not going to lay them all on you guys at once. We're just going to start real small here. Baby steps, right, Davey?
That's right. Only way to do it.
And so the first place I want to start is one of the deals that she refers to as a individual song agreement. Now, just as a point of reference for everybody, when we talk about publishing deals, we're talking about you as a songwriter making some sort of agreement with a publishing company whose job is to bring in additional revenue for your musical work, basically. However, the deals that you make with these publishing companies look very different depending on what it is that the deal is about. So the very first one is individual song agreement. And so, Davey, can you, when we talk about an individual song agreement, we're referring to one song, right? And just the musical work. Oh, okay. Juiciness already. Our audience is predominantly independent artists who may also own their sound recording. So with that being said, Davey, you may need to step into that role as well. So can you talk about your expertise with regard to the individual song agreement?
Yeah, I mean, so when we talk about, obviously making sure we're separating and keeping clear the difference between your publishing side rights, which is what we also call your musical work, versus the sound recording stuff. So because those are 2 separate copyrights and they're subject to different licenses, different streams of revenue. So we got to keep them, even though they're kind of like a peanut butter cup, right? And the publishing in the middle and the sound recording on the outside. You still have to keep them separate. Who doesn't like chocolate?
That's a really good reference.
I know. I'm stealing that one too.
Me too.
So you gotta, even though they are entwined like that, you've got to separate them in your mind. Because like I said, different copyrights, different streams of revenue and all that other stuff. So when we talk about publishing, we're talking about the musical work copyright. And so that one consists of the composition and the lyrics. So basically anything that could potentially be sheet music, but you don't have to put it on sheet music, but that kind of stuff. The notes, the arrangement, the lyrics, the melody, all that stuff. Versus the sound recording is capturing the performance and the work of the producer. So just think about to conceptualize it is when you think about cover songs, those are multiple different sound recordings of the same musical work. So when we talk about publishing, we're talking about just the musical work side of stuff, not the sound recording stuff. Well, right. That's a discussion for another day, is the sound recordings and those agreements. But so there's that. So when we talk about an individual publishing agreement or songwriting agreement or a single song agreement, as they're often called too, it's an agreement for one or more songs. But if there's more than one, they're identified, it's cherry picked. So it's not all the songs you write throughout your entire career. It's not all your catalog of songs. It's not everything you wrote in 2022. It's this one song, or it's, I like this song and that one and that one. So we'll make those part of this one deal, right? And so what that means is that you are still free in regards to the entirety of your remaining catalog to do whatever you want with other publishers or with other people, or to do nothing at all with them. They're not part of this deal, right? So that's the main distinguishing feature of this type of agreement, is it's really about an individual or a group of cherry-picked songs that are subject to this agreement. And so, subject to this agreement, what happens is the publisher's like, hey, I think these songs are great. I think they have potential. I think I can do something with them. And so transfer these over to me. And then what will happen is me, the publisher, will then go ahead and help you with licensing this music out. And when we say license, we just mean granting others permission to use it in a certain way. Which is how money is made with your music, is by and large, it's through granting people permission to use your work. So whether that be through, downloads, whether that be through performances, whether that be through licenses for synchronization to use it in connection with a film or television commercial, TV commercial, video games, micro licensing, like, little video clips on social media and stuff like that. Those are all like synchronization licenses, right? And so generally those come with an upfront fee. And so the publisher is the one that executes these agreements on your behalf, negotiates them for you, collects all the revenue that is due to you, and then gives you your share. And by and large, what you're going to see is a 50-50 split on the money that's generated in connection with those individual songs. So that's the very high level overview of what that agreement kind of looks like.
Do you have to give up 100% of the rights to the song in this type of agreement? And for how long typically would you say?
I mean, everything's negotiable until it's not.
Yeah. I'm going to get her a paddle that just says, it depends. It depends.
It depends.
Preach. Because it does. Because, while there might be with anything, there's always going to be what we consider industry standard. What happens a lot. Okay. But then again, not everybody's the same. Not every company's the same. Not every songwriter is the same. Not every song is the same. And so with all of these variations, we take that into account. And that's where the work of somebody who can assist you with these negotiations really come into play, that are very important, whether, you've got your attorney working for you, or if you've got a manager who's really, really well-versed in this kind of stuff, somebody who's negotiating these deal points for you, because that's where the beauty in all of this lies. And that's where the key to success is, knowing where to push and where to pull in these agreements. So sometimes you might say like, if it's a smaller publishing company and, maybe it's a startup, you don't want to give them your rights from now until the end of time. Whereas if it's a larger, more established one, you'd be like, yes, please take them. And I have more too if you want them, so that's the key to a lot of these deals, is that, while it's fair to say that we have what's, quote unquote industry standard, there are times when industry standard is the wrong thing.
That's challenging. So I guess, that kind of makes my next question, I guess, even harder to respond to, because since there's so many variables depending on the situation, is there anything that you can think of that's maybe like a red flag in these types of deals? Something that like, if you get approached by a publishing company and you're looking at it and you're like, oh no, like, is there anything you can think of?
Oh yeah, lots of them.
Oh, okay.
Lots of red flags. Whole parades.
Oh yes.
Yeah, absolutely. Like sitting there flipping the flags like color guard. Yes. So number one, always across the board, is a sloppy contract. Because that tells me they're not handling their business. And it tells me how seriously they take their own business. And if they're not handling their own business well, they're not going to handle your business well.
And what do you mean by sloppy contract?
Sloppy contracts will, sometimes they're really, really bad and easy to spot. You don't have to be any sort of, contract professional to even notice it. Incomplete sentences that just are, one I looked at today, missing verbs. Like, y'all, this needs a verb. Like things like that. When the agreement conflicts with itself. So, for example, one I looked at recently said, you hereby grant us a power of attorney to enter into all of these types of agreements on your behalf. And then the very next sentence is, you do not give us the right to sign contracts for you. And I'm like, but now, no.
Yeah.
So things like that, like that's, like, and that's, where I sometimes I feel bad for people because they're like, this is so confusing. I'm like, well, yeah, because it doesn't make sense. Like, because there's a difference between like getting tangled up in the legalese where you can be like, I just don't understand what this means,
Right.
versus something that is very clearly plain English contradicting itself.
Right.
Also, sloppy is when I see things that are the numbering's all off. You can tell it was a Frankenstein job because they didn't even bother switching it all into the same font. And so they've been using like, I'm going to pull this from here and pull it from there and just cram it together. And, so like, and then also what we see is disagreements in the terminology. Like it might be saying, it might additionally identify you, the songwriter, as the writer. So it'll be like, this contract is between ABC Publishing and Jane Smith. And then after Jane Smith, it'll say, in quotation marks, writer. And then it'll say writer, writer, writer throughout the contract. And then it starts saying talent, creator, like artist. And, you're like, those things, like, nobody ever smoothed out the rough edges of that. So it tells me like they're not taking the time to even look over what they've got. So it concerns me. Like if they're not, that's one of my tenets in my business is if they're not handling their own business, how are they going to handle your business?
And based on what you're saying, that's not even exclusive to a publishing agreement. That just sounds like contract basic in general.
Yeah, that's a basic across the board. So there's that. Generally, other things that might not be, there's lots of other red flags that can be in the contract itself. When it's publishing specifically, things that when you never have any approval rights whatsoever. So generally, for example, in a publishing agreement, if you're giving the publisher the right to grant synchronization licenses, so to use your song in connection with visual works, you should have an approvals clause in there for certain situations where you have to be consulted and you have to either, grant or deny approval for that particular use. So at the very least, those should be for what we call sensitive or consider sensitive uses. So things that are like alcohol, tobacco, firearms, politics, charitable causes, things like that, stuff that is bound to be divisive. Religion. Yeah. So, and you can throw in anything else that you feel strongly about that. If you're like, I hate cats, like I don't want my music used with any cats whatsoever, then you put, a feline clause in there, whatever, but if there's something, so there should always be that so that you still have a level of control over that. So be careful with that. There's other things as far as just in general goes, like, I always do my, due diligence on who the parties are in the agreement before I even start really reading the agreement, because that's going to tell me a lot too. There have been times where somebody's presented my client a contract and it says, ABC Music Inc., and it'll say their address is in Florida. And then there is no ABC Music Inc. in Florida. And it's like, okay, so are you not actually a corporation, or are you not a corporation in Florida? Or are you doing business illegally in Florida? Are you misrepresenting your status? Like what's going, we want to make sure that it's an actual legitimate business registered with the state to do business, which you can check in every state. You can go to the Secretary of State's website and look at the Division of Corporations, and you can just Google whatever the state name is, put an entity search. So Florida entity search or Virginia entity search, and it'll, pop you right up in your top of your search results, the Secretary of State site, where you can just put in the name and it'll pull it up for you. So you want to make sure that that's, legit. And the other thing I look at while I'm there is like, even if it has been formed within the state, I click on that and see if I can pull up their history. And there have been some where it's like, oh, this company was formed in 2015, dissolved in 2016 for failure to file their annual report, reinstated in 2016, dissolved in 2017 for failure to file their annual report, reinstated in 7. You know what I mean? Like if they just keep, and it's like, again, these are indications that they're not handling their own business very well. So I don't have a lot of faith that they will do well by my clients. So those are kind of some red flags to look for also.
Would you?
Um, a-
Sorry. Go ahead, Lennon.
another go ahead. Another thing that you brought, I think we talked about this when you were on my podcast like years ago, and I think it was when we were talking about downloading like fake contracts online or like template contracts and how bad they were. And one of your clients had brought something to you, and you're like, well, who's from Finland?
Yeah.
And they're like, nobody. So why does it say Finland in the contract here?
Right.
There's no jurisdiction here. You have to go to Finland to fight this.
Right. Yeah. I mean, and that's like the crazy stuff I see quite a bit, like where you're just like, what? Why is that even in there? Like, and it's, like, and even I was looking at something and talking to a client the other day, and I was just like, I don't think this other person had any malevolent intent. I think they were just like, well, this sounds legal, like this. But the reality of it is like, it made no sense being in the contract. And, like this clause was just like totally out of place. It's like, fixing your carburetor with a container of Jello. Like that's what. And of course, now somebody's going to hop in the comments and be like, well,
Yeah. It can be done.
You probably could. I don't know.
With the individual or single song agreement, should I be cautious, or should someone be cautious about if there is a clause in there regarding future songs written, or is this agreement supposed to be specifically about the selected songs that have already been written?
It's generally by its nature just about existing songs.
Okay.
So usually when we start looking at agreements that talk about future songs, then we're looking more at like exclusive songwriting agreements or something like that.
Okay.
Like, so that's like a different type of publishing agreement. So at that point, it would kind of edge out of the realm of being a single song agreement. But, that being said, like there's no hard and fast rule that it says that this contract couldn't possibly say that. And even if it did, it wouldn't make it inherently bad, because the overarching, theory behind contract law is freedom of contract. So you can contract for pretty much whatever you want. So if, the publisher did put in, that they want these 3 songs, but they want an option for your next song, they might propose that and you might agree to it. It's not inherently bad on its own. It really just depends on the totality of the deal.
And I think, and again, Davey, you're the expert here. Could I say it's fair that even if they did ask for that sort of option in the contract, you're still free to negotiate the terms, like, you balance it out. So if they put that kind of option in there, you can, should I, or do I have the freedom to be like, okay, well, if you guys want to do that, then here's the stipulations of me agreeing to it?
You could try. Generally, when they want to do something like that, they'll say subject to all the same terms of this agreement.
Okay.
So like if we take the next song, it's going to be as though it was part of this contract from the jump.
Okay, right.
That being said, again, you're always free to negotiate, so if it comes to the point where, the first 3 songs did really well, and then now we wrote this next one and the publisher listens to it like this, they're like, this one's a banger, like, and that's when you're like, I think maybe we should talk about our deal and look at it again. Because while they absolutely could hold firm to what the existing deal points are, in my experience, that's not always what happens. They, are willing to at least consider renegotiating it, especially if there's been some success already. Right. Because you're never, a new artist or a new songwriter is never getting the best deal the first time out. You're just not, like
I've heard that.
It's like your first credit card. You're not getting the best interest rate either. Like
No.
it is
unless
what it is.
Unless you shop around.
Well, I mean, you can shop around and get what's best for you.
Right.
But you're not getting Taylor Swift best.
No.
Because
you don't have the track record to back that up.
Exactly. Right. And so once you start building that up, and once there's a bit of a history, a lot of the times in my experience, the publishers want to keep the harmony and they want to acknowledge the success that's been shared. And, a lot of that also has to do with how well you've been working with your publisher. Like, have you been, like when they reach out to you for approvals, are you responding to them in a timely manner? And are you, discussing with them as far as like, hey, look, I've got this other release coming up. Just wanted to let you know about it. This is what's going on. So we're not, stepping on each other's toes while you guys are working these songs. I've got these songs and this is what my plans are. So that way, you're really a good business partner with them in regards to your songs so that you're collaborating for the success.
So you have to do your part too, as far as your level of professionalism and, due diligence on your part.
Yeah, and I will tell you, I've had publishers tell me in the past, like, some of them, there have been times when it's been, yeah, we'd love to be able to do that, but, to paraphrase, your client kind of sucks. And I'm like, oh no.
Oh, no.
And I'm just like, but, they're creatives, they're artists,
Yeah.
and then at the same time, I'm like, God, don't I know it? I can't get them to answer an
Right.
email, so I feel the publisher's
Right.
pain, and because they're a business
Right.
too.
Yeah.
And you're making it hard for them to make you
Right.
money.
Mhm.
So there's that. And then I've seen the other side of it too, where it's like, no, we love working with your clients. They're
Mhm.
awesome. Happy to,
Mhm.
explore what else we can do. So it absolutely, bears fruit if you nurture it.
Sorry, Mo, I know you're just like
No, you
chomping at the bit
go.
here to get all the
Go. I
questions
can't
in.
wait.
Um,
Can I put
I
on the
noticed.
card, like do tally marks for you guys?
Mo would win. She's always got
I
questions.
just,
She's always
when
got
Davey's
questions.
answering, I'm like, oh, okay. That
Yeah,
brings
I
this
know.
to
Same.
mind.
I'm like, I've got my little
Look, I got
notepad
a
where I'm just like
notebook.
taking notes. Yep. So for artists and smaller songwriters that are looking to get into a publishing deal, maybe they find that that's the next step for their career. Do you find that chasing after maybe smaller or medium-sized publishing companies are better or more fair to smaller artists than going after like a Warner Chappell or Sony ATV?
You're gonna find it more difficult to get in with Warner or Sony if you don't have any significant metrics.
Mm,
Like you're not suddenly big on TikTok or something. Like it's just you're
oh,
gonna, it's gonna be a hard time getting that level of attention and getting them interested in you.
okay.
Whereas with the smaller, mid-sized, what you just need to be a little bit more cautious in who you're working
Mhm,
with. Like
mhm,
not that you don't need to exercise some caution with, Warner or Sony's of the world, but they are the larger, more established. They've got a veritable herd of attorneys, so it's not like, we're going to have to worry about them not knowing what they're
Mhm.
doing.
right.
Whereas that is a concern with maybe your smaller mid-size. You need to make sure that, hey, these guys, they know actually what they're doing. They've been in business for a while. I see these other people getting their, work placed. I see the success they have with other people, and that's a bit comforting. So, that's kind of,
Mhm,
but they're definitely the smaller mid-size are definitely easier to become involved with for that reason because,
sure.
they're not Sony or Warner. So
Mhm,
With these
okay. Good
single
to know.
song agreements, Davey, what are the rules of engagement if I've already had this deal in place and now another publishing opportunity arises? Am I allowed to enter into multiple publishing agreements?
oh, that's a great question.
I love that question.
It depends. So
She was waiting for that. She
no,
was
I
waiting
like
for that
it
one.
because it's not just because I get to drop the it depends on you. But because sometimes that is like the predicate for like a fantastic situation. So like let's say you're signed up with this one company and something blows up and suddenly other, bigger, publishing companies are sniffing around and like, hey, what do you got there? Like,
Mhm.
hey, is that free? Like, is that with anybody? Some even though it might be under contract and the contract might be like, hey, from now until the end of time, it's with that publisher. That being said, the smaller publishing company is still going to be very aware of the fact that there's bigger fish in the sea who have a larger war chest and might be willing to be bought out.
Mhm.
So that puts us in this really cool spot where it's like, okay, well, we can entertain offers, but we have to be upfront and say, well, that one is under contract, and it's with these people. But we might be able to work something out.
Mm.
So,
Mm.
and part of the motivation of the smaller publishers, like, why would they let that
Mhm.
song go? It's the same as, like, I don't know, why did Sub Pop let
Mm.
Nirvana go? Because, you a lot of times have more opportunities with the bigger
Mm.
organizations. That just is
Mhm.
what it is. They've got more money, they've got more reach, they've got more
Mhm.
manpower. That's why they're able to do what they do. And so the smaller companies will occasionally upstream to a larger company, whether it be for a flat payout or a smaller upfront payout and a percentage of the royalties, because they understand that this bigger company can generate more money with it than they can.
Mm.
So, it actually behooves them to, upstream that music. So, that could certainly be the situation. Um,
Um, do artists, I know you're talking about the clause for people who, where you can have a say in where the music goes. Does this also apply to stuff like this, where the artist would get a say on the buyout? Or is this completely 100% the publishing company to say, nope, we're going to sell these 3 songs of yours to this company?
I'm so sorry. It depends. So,
Mm.
so your contract with your first publishing company will have a section that deals with assignment. So, this clause may say that the publisher can assign their agreement to a third party willy-nilly without your
Mhm.
approvals. In which
Mm,
case, then yes, the publisher could just of its own accord say, guess what? You're with
Mhm.
Sony now.
mm,
This song is now going to be, this is a Sony song. We just went ahead and assigned the contract. So it's entirely
mm,
possible that could happen. It
mhm,
might have an assignments clause that's assignment with approval or assignment with notice. So it could say, oh,
mhm,
they can assign it, but only if they let you know
Mm.
first, or they can assign it, but only if you give them approval first. So these
mhm,
are all things that we negotiate, right?
mhm,
So it could have any of that language in there, or it could say it's not assignable at all,
mhm,
unless both parties, the publisher and the writer, agree to change the contract. So it could be a situation where the publisher, if the contract says so, could go ahead and whistle it
Mhm.
off to someone else.
mhm. Okay. Yeah, I like how even though it does it's kind of a running joke now is it depends. It just shows how flexible and how maneuverable these contracts can be.
Yeah.
And all the little details that you throw out is like there's so many things that can happen.
Yeah.
And going in and explaining like, oh, it could do this, it could be this. It's like, okay, that's good to know. Now
Mhm.
when I go into this, I want to do
Mhm.
this. Davey said this. I want to try this. What do you
And I
think
want
about
to
this?
Yeah. And it's,
It gives
what
that
kills me is, like,
information.
one of the phrases I most dislike in the world is a standard contract. Cause I'm like,
yes.
that doesn't exist.
Right.
No.
That's
Right.
a mythical creature.
What does that even
Because
mean?
yeah, they're all subject to negotiation. They can all change. And that's just like me saying, well, Lennon, it's just
Mhm.
your standard song.
Mhm.
You know what I mean, right?
Mhm.
You know what it sounds
No.
like when I say that. You know
No.
exactly what notes are
No.
where,
No.
right? Like
Right.
it's the same kind of
And I
idea.
just want to
Yeah, same thing.
something that happens a lot and I want to clarify. So in Lennon's question, he said the artist. I think it's important to recognize that the artist is not always the songwriter and that it's about who actually wrote
Yeah.
the song, not necessarily who the performer was. Um, the other thing I want to
Yes.
ask you, Davey, is the recommendation, of course, is get an attorney to help you with these sorts of things, right? Um, if I were a manager doing this, I would likely expect a percentage, yeah, of the deal that I negotiated. So if I'm working with an attorney, and you can go both ways on this one, manager and attorney. If I hire an attorney to negotiate with the publishing company, and I'm new to this, I'm already, in my mind, I'm already paying the attorney to handle this for me. Should I also expect to pay an attorney a percentage of this deal somehow? Or what are the legalities involved here?
So that's a great question. So as far as, like, the manager goes, just to be clear, like, 99% of the time, I think a manager is good for the big deal point negotiations, like things like, the big items, and then without necessarily committing to that, then going over to the attorney and saying, okay, we've gotten close enough to where we think this could work.
Mhm.
Now it's worth paying the attorney for. And then, as far as like the percentages go, the manager generally is going to get a percentage of all revenue anyways, regardless, across the board, whether or not they had, anything to do with it. Most management contracts are going to state that, the management's commission is a percentage of revenue generated with the artist or writer's
So there
activities
should
in the
not be
entertainment
anything
industry.
additional added within the publishing agreement. Right. Right.
For the manager?
That's what,
No.
that's what I'm looking for, is
No.
because again, there's a lot of scam artists out there, a lot of those Lou Pearlman type of people who, here's my management agreement. Okay. Now I'm also part of the band. Let me get this little nugget too. So I want to make sure we're clear with everybody that
Right.
your manager should not be doing all this little dipping and diving. Right.
There should be no double dipping at all. You shouldn't be hitting
Right.
like 2 bites of the same
Right.
apple, and that's what that would be.
Mhm.
And then, you also mentioned something about like an attorney taking percentages. Some attorneys do. Some attorneys will base their fee on a percentage of a deal. More often than not, it's when an attorney shops the work, like tries to get a placement. But not always. Like sometimes that's just the attorney's fee is like, oh, I'll do it for, whatever percentage of whatever. I'm not a huge fan of that in general. Just because I just don't, for me, I don't feel like for me that's the right thing to do. Like I'm like, I know how much
Sure.
time it's going to take me. I know what I charge anybody else for this kind of stuff. Why would I charge you? What could it essentially work out to be like 1,000 times more than I would charge somebody else for the same deal, like for the same amount of work, like just because you can, I don't know. But sometimes attorneys do charge a percentage. Otherwise,
And
it
if
could
an
be hourly
attorney
or flat.
does get a percentage, just so we're clear, they do not get listed as one of the writers. They just are taking a piece of the revenue when it comes in. So the attorney will never show up on ASCAP or BMI's database. It's just the contract says when you get your money in for this, make sure you send a piece over here.
Right. Yeah.
Right.
So
They're not
generally
getting
that's what it is
ownership.
the
They're just
attorney
getting,
gets paid out
Mm.
after everybody else is. No, they generally don't. And honestly, I've seen
I
some
like that.
attorneys do that. And there's going to
Me
be
neither.
few situations where that's not sketchy as hell. Like it's just and that's something where I'm like, ooh, for me, even the thought of entertaining something like that, I'm like, absolutely not. Like I do not want to be known as the attorney who takes ownership or a share of your work. Like that's, to me, I couldn't. But I know that some people do that, and it's a very fine line to walk as an attorney as far as staying within your ethical bounds as to whether or not you can even do that. So
Yeah.
Well,
That
I
does
guess
sound
we'll
really
stop
sketchy.
there because it is a series, and obviously that was just one of 6. So I can't imagine what these other agreements are going to look like as far as, how they're negotiated and how they differ from just a single song agreement. So, Davey, thank you so much for your time today, as always. We look forward to absolutely.
Thanks for
And
having
again,
me.
everybody go check out Meehle and Jay's social media. They are, first of all, they're a firm with a great sense of humor. I got to say that. And they put out great content to help those in the industry that are trying to get things right. And so I truly appreciate you guys and your transparency, Davey. I think that says a lot about your integrity as an attorney. And I'm not saying that just because you're my friend. As an educator, as you know, it's important that people get the right information. And I like the fact that you are one of the most ethical attorneys that I've met, and I appreciate you giving us your time. So thank you. And I guess we'll see you on the next one.
My pleasure.